Hello, I'm Dori Kimel, and this is about the philosophical foundations of the common law, a course which, as you may know, is something of a BCL classic. It has been running continually for some 30 years. And I think that the main explanation for this unusual longevity is the fact that this course has always been a truly collaborative effort. It is unique in being delivered by 7, 8, sometimes 9 professors every year. 2 or 3 of us usually lead each seminar in different combinations. And the thing is that we each bring to the course different intellectual backgrounds, different perspectives and takes on the material, sometimes contrasting takes on the material, and even different styles of delivery. And I think this has always given philosophical foundations a dynamic feel and a certain democratic ethos, and made it an exciting course to be a part of, and for all participants, faculty and students alike. Now, the first question I would like to address is, who is it for exactly? Now, we have philosophy in the title, and yes, this is a philosophy course. But what I would like to emphasize is that it is a philosophy course for lawyers, and it's a course about the common law. We're interested in bringing philosophical analysis to bear on substantive law and on concrete legal doctrine. So we don't presuppose, we don't require or expect any prior philosophical knowledge or philosophical education. And the course is designed for everyone on the BCL and the MJUR who is interested in the questions we explore. I think the course works well as part of an individual BCL program that majors on philosophical or theoretical choices. So alongside jurisprudence and political theory, 1 or 2 additional theoretical courses, obviously it works well. But it works equally well as the one philosophical or the one theoretical subject in an individual program that otherwise majors on technical subjects or on black letter law. And I want to emphasize that this course really works well for people belonging in the second group, if only in terms of workload and also in terms of the style of work that we do. Philosophical Foundations is not focused on case law. And because it is a philosophical subject, we naturally pursue depth and nuance much more than sheer coverage. So the reading lists for the course tend to be fairly small, fairly compact. And moreover, throughout the course, our students are also able to choose which topics they would like to explore in greater depth, and which topics they are perhaps slightly less interested in, so that they wish to merely familiarize themselves with them but go no further. There's a great deal of flexibility in this regard, and we make sure that this flexibility is accommodated and that students' individual interests are respected, even when it comes to how we structure the final exam. And I will say a little bit more about it towards the very end. So the upshot is that this course is for everyone who finds the questions we investigate interesting. So what are these questions? Well, the title of the course, The Philosophical Foundations of the Common Law, is straightforward, it's descriptive and revealing. The course is divided into 3 main parts, corresponding with the main 3 branches of the common law. That is criminal liability, contract, and tort. In each part, we explore the underlying rationale of those branches of the law. We ask what is distinct about them and about the types of liability they create, and we explore the philosophical and the moral and the political foundations of their main principles and doctrines. Now, in the process of doing that is in the process of acquainting ourselves with the philosophical foundations of each of the main branches of the common law, in turn, we also take the opportunity to investigate a host of so-called crossover questions. That is, we explore the relationships between those different branches of the common law. And we also explore the precise meaning and significance of various legal, moral, and political concepts that arise fairly routinely throughout the common law and allegedly or seemingly lend the common law as a whole some sort of philosophical or doctrinal unity. So, for example, we gain a deeper insight into the nature of contractual liability by comparing it to tort liability and vice versa. And we analyze tort liability in part by way of comparing torts to crimes, and we compare the rationale of defenses to liability that we can find in each of these branches of the law, and explore the reasons for both the similarities and the differences that we find in this area. Why is it that certain defenses are available in criminal law but not, say, in tort or in contract? But we also ask whether concepts such as personal freedom, moral autonomy, causation, intention, harm, justice, and so on, concepts which figure both in the practice and in the theory of all three branches of the common law, lend the common law as a whole some genuine doctrinal or philosophical unity. Alternatively, if it is the case, or to what extent is it the case, that these branches of the law in fact represent different moral principles or different political aspirations. For instance, that one is to be understood primarily as embodying principles of corrective justice, whereas others are based on considerations of distributive justice or retributive justice, or on something else altogether, such as the pursuit of market efficiency, or the enhancement of personal relationships, or free choice. So the overall aim of the course, accordingly, is that participants emerge first with simply a more robust knowledge of each of the main branches of the common law and the theoretical foundations of each of the main branches of the common law, but also that they emerge with a theoretical overview of the common law as a whole, with an idea, with some picture of how that whole great normative structure hangs together to the extent that it does. So for the full list of subjects we do, and for the reading list, you can of course look at the reading list for the course on the faculty website. I will say something quick about the structure of the course and on how it is examined. So structure first, the main format of teaching is seminars, and we have 6 seminars each on the 3 main branches of the common law, that is on criminal liability, contract theory, and tort theory, and 2 additional seminars on causation for those who are interested in this fascinating topic that of course runs through the common law as a whole. On top of that, we also have 4 small group tutorials, so each student receives 4 tutorials where you get to practice essay writing. These tutorials tend to be very enjoyable, as well as serve the purpose of exam preparation. So there's usually 1 tutorial each on crime, tort, and contract, as well as 1 tutorial devoted specifically to writing essays on crossover questions. So this is again very useful as a means of exam preparation. Now, as for the exam itself, the emphasis here is on the fact that we offer plenty of choice as well as a fixed structure. And that is designed, as I mentioned right at the start, to enable students to choose which topics to focus on according to their individual interests. So it's structured like this. We have 2 questions each, I should say 2 either-or question each on the main branches of the common law. So an either-or question on criminal law, tort law, and contract law. We have 3 crossover questions, 1 each on contract crime, contract tort, and tort contract. We have an additional open-ended questions, that is the question that can be answered by reference to any or all areas of the common law. And finally, a question on causation for those students who are interested in causation, and you have to answer 3 questions out of this selection. I think this is part of the explanation why our students, we always hear it, they say that they enjoy the exam. We hear that after the exam that people actually enjoy the experience, and I think it's partly because of the structure, because students can focus on those areas that they they are interested in. And also the whole ethos of the exam corresponds to that of the course. So when we ask the exam questions, we never pose them with the blueprint for the perfect answer in mind, with a fixed idea of how each question should be answered. The exam questions are genuine invitations for students to engage with material that they find interesting and to use their own voice, to offer their own take on the material, which also explains not only why students tend to do well in the exams, but why it's often the case that when we mark, we read two answers to the same question back to back. They can have absolutely nothing in common. Different theses, different literature is drawn upon, different examples, and yet both efforts are first class. This is quite typical for this course. So I hope this is helpful. Please don't hesitate to contact me by email should you wish to ask me any questions. I'd be very happy to advise you further on whether or not this course will be a good choice for you. And of course, whichever courses you choose, I wish you all a wonderful year on the BCO and MJOR. Thank you very much for your attention.